Hi, I'm Holly Richardson. Welcome to this week's edition of On Point, presented by Sutherland Institute. I write the blog Holly on the Hill, and I am joined today with Michelle Mumford, who was recently released as the Dean of the BYU Law School. Not yet? Okay, never mind. See, I knew I was going to mess it up right out of the gate. Yep. So an attorney. I'm joined all by attorneys, by the way, so you're going to have to talk to my level today. Kurt Bentley, who's an attorney and political writer as well, and then Bill Duncan, who's an attorney here with Sutherland. We've got some things to talk about, the primary election that just finished here in Utah, and then a 10th Circuit decision and 2 Supreme Court decisions today.
That's right.
Yep. Do you want to start with the primary stuff and get the easy stuff out of the way?
Sure.
Okay.
Yes, yeah.
So this week we had primary elections. We didn't have that many on a legislative level. We had a few. Does anybody want to weigh in on any surprises, anything that you saw that happened this cycle?
Here in Salt Lake County, we have the, I always want to say
assessor. The assessor's race.
The assessor's race.
And it was Kevin Jacobs, right?
Versus Parkinson.
Jake Parkinson.
And Jacobs was the incumbent.
Yeah.
He was put in by the Salt Lake County State Central Committee.
County Committee.
The County Central Committee, yeah. So he was kind of the incumbent, but he hadn't been there for long.
Yeah.
But he's been in the office for 20 years working.
So he won.
Prior assessor, he won.
He won.
Yep.
And then, did you have county council races? Is that something that was on the ticket for a primary?
We didn't have a primary for county council.
Okay.
We had a Senate against Senate 2. It's DeBacchus's.
Yes.
And
so Jackie Nielsen.
Jackie Nielsen won
came
that.
up on top of that.
I think that none of those were really surprises.
Right. So we had in northern Utah, Mike McKee is a commissioner who's been there for a really long time up in Uinta County. And he, by the end of the night, on Tuesday night, he was ahead by 9 votes with 90 outstanding mail-in and provisional ballots.
Right.
So I don't know if he's going to hold on to his seat up there. That's probably the closest race in the state.
That was like watching the Cochran race that night. Cochran and McDaniels, they just kept going, it was like
back
getting closer, and then it was, but it
9
was,
votes, man. So I think
yeah.
that's going to trigger an automatic recount, but still up in Uinta County, that one was really tight.
Right.
In Utah County, where I live, Bill Lee won over Lauren Gerson, commissioner, for commissioner race. Jeff Buman, who's the sitting county attorney, won re-election.
That's right.
Or as the nominee, actually. And then Dana Layton and Brad Daw were the 2 legislators that were in a race. Actually, a former legislator and current legislator. There were 3 of those races this time, and he is the only one that was the previous legislator who defeated the incumbent legislator in this go-round. So he will be the Republican nominee on the ballot.
And that was the race that was the Jason Powers and
John Swallow.
John Swallow, and she felt like she never really got out under the Jason Powers.
Yeah, I don't think she ever really did,
cloud.
and I don't think that she was really tightly tied with him, but she was never able to really get in front of the messaging. And I know at convention, Brad Daw's wife was able to stand up and hold the front page of the newspaper, right, with the story that came out in December that said their goal was to take him out at the knees, really, and that he was their target, $45,000. John Swallow and Jason Powers, and they had colluded to end his political career.
And so they had dropped signs off on her yard, and she said she thought it was from the campaign.
Right, and then after the primary was over, then she got a phone call that said you have to report these as an in-kind donation. And I mean, but in any case, Brad Daw did prevail in that race. And then down south we had
Iron County.
Yeah, Evan Vickers against Casey Anderson, who is a former legislator, and then Blake Cousins, who's the chair down there, Utah County GOP chair of Iron County, was running against John Westwood, and both of the incumbents won easily. Handily. They were 70+% over their challengers, somewhere in that neighborhood. So,
any surprises for you there? Are you what counties do you live in?
Utah County.
Utah County.
Utah County.
And I'm in Davis.
You're Davis, right?
Yeah. We didn't have a whole lot going on. On my ballot, there was only one race, and that was County Commissioner Brett Milburn versus Brian Muir.
Yeah.
Milburn being the incumbent, and he won. He won fairly easily. Yeah. Not really close.
So how was your turnout?
Good.
Really?
Relatively speaking.
For primary.
Yeah, it was all vote by mail in Davis County.
So explain to me about that, because I was actually on the Davis County website on Tuesday, and instead of saying, hey, make sure your ballots are turned in. It said, here are your 6 or 8 locations to go vote today. What was up with that?
Yeah, so they mailed the ballot out to everyone, and you had to postmark your ballot by June 23rd, I think, in order to vote by mail. And if you didn't, you could take your ballot to...
Your mail-in ballot, you could
You
hand
could take your
deliver
mail-in
it
ballot and hand deliver it, which is what I did.
on Tuesday.
I always
Interesting.
wait till the last minute.
Well, that's good because there was, there's always the scare that, oh, well, if I don't mail it in, I'm out. And,
Right,
how can you
right.
do that for Election Day? So at least there was a way on Tuesday that they could
Yeah.
go.
So did they, was it, why did you guys go to all mail-in for the primary? Is it a money-saving thing? Probably not tremendously if you still had polling locations
Laboratories
open.
of democracy.
Yeah, I'm honestly, I'm not sure. They had polling locations, but only a few. There were
Yeah,
just
a handful,
one-
fewer than normal.
Oh yeah, much fewer than normal. Just one in each city.
Uh-huh.
One in Layton, one in Farmington.
Did your neighbors like the vote by mail?
They did.
Do you think that it will be for general as well?
I don't know.
Interesting. Yeah, I thought that was interesting up there. There was another race up there in the Bountiful area
Right.
for Jim Nielsen's seat, and he chose not to run again. And so you had Chet Loftus, who's an attorney, running against Ray Ward, who's a physician, and also tied in with the school network up there. And,
That's right.
and Ray Ward was
Ward
the one
won.
who won.
Yeah.
But every county that did the vote by mail specifically had much
Higher turnout. Well, I think there's some, we're still certainly
We're single
precincts.
digits.
Single digits. Yeah. Single digits. Fewer
Embarrassing.
than 10%. Yeah. Yeah. Exactly. There were people who said that their precinct, their turnout was less than 2%. They
Right.
had somewhere in the neighborhood of 1.5%.
It doesn't
turnout.
help to
It's-
count my vote argument. Like, everything should be done by primary. Okay.
Yeah, 1% turnout. Woohoo! So yeah, and some of the reason is there weren't any high-ticket races really on the ballot. There were no congressional
State.
races. There were no statewide races. There was nothing that really generated a lot of interest. I mean, you can't even remember. Is it assessor? Is it auditor? What's that?
I know.
Right? And we're really
I think we had school
involved
board
in
as
it.
well. Yeah, you're right.
Right?
You're right.
We're really involved, and so we say it's a what? Who is that?
But I think
right?
that's my math blockage. Assessor, auditor. What do they do? I don't know.
Sure.
I don't know.
So anyway, so the stage is set for November, and I was able to go on one of the local TV stations, and they wanted to talk about the November races, and so I was up with the chair of the Democratic Party, Mayor Peter Caroon, and
That's right.
it was just very funny because they asked us about the Meal of Doug Owens race, right? And he does his little spiel about how Doug Owens is such a strong candidate, and I said, come on. You've done a great job representing your party. That's what you're supposed to do.
Okay.
But we all know this is not going to be a contest.
Do you think there are any contests in November? You think AG?
No. Well, I don't think on a statewide level or congressional level, federal
Right.
level, but I do think in some of the House races. So there are some in swing districts.
That's true.
So I think Sophia
Especially the
DeCaro
filling
has
the
a
vacancies.
chance.
Right.
Yeah. I think Sophia DeCaro is a very strong Republican nominee. It's House District 31, and she's going up against Larry Wiley, who's the incumbent. But he won by less than 100 votes last time
Right.
against a candidate that wasn't as strong as Sophia. And so she has an opportunity, I think, to really make that seat change hands. We'll see how it plays
She has
out
a
in the
great
fall.
Chamber of Commerce background, too.
Well, and it's not just that.
Experience.
Yeah, she's over at GoEd right now. She just yesterday was named the interim executive director as Spence Eccles has stepped down, and so she's also Hispanic, and she's got this background in her community as well. And I think she's going to be a very strong candidate. So that's one race
I saw that
could
go-ed.
watch.
It made me nervous. I was like, no, she's going to win her race.
It's because
Don't pull her into
that's why
go-ed.
she's the interim, right?
Okay,
because if she
But
wins,
she's got stuff to
if
do.
she wins her race, she can't be at GoEd. Yeah,
Right,
yeah,
right.
yeah. So that's one that could be interesting to watch. I mean, most of the races have been decided at this point, right?
Yeah,
By
I
the
think
time
so.
you get past the primary, most of them are decided in Utah. I mean,
Is there anything up in Davis that's up for grabs?
I
Does
don't
it
think
seem?
so. No, not really.
yeah, I mean, there's only going to be a handful of races that are going to make it,
Right.
fun to watch. I mean, it's always fun to watch, but.
We'll have to come up with some kind of.
There's always a surprise
So,
somewhere.
so
Scandal.
speaking of the Love Owens race, and then we'll move on to the court decisions, but I read recently that Mia is planning on raising and spending $5 million on this race.
Wow.
right? And there's no way that Owens can match it in fundraising, right? Matheson had an incumbent advantage. He was able to get some of the big endorsements. He got the Chamber of Commerce, and
Right.
not this time. It's all going Mia's way. So
One of the issues last time was that she seemed to have a real national presence, and she was spending a lot of her time doing that as opposed to knocking doors.
yeah.
When she's spending her $5 million, is she going to be knocking doors as
She
well?
is, and she's doing media buys and mailing. And one of the things that Mia's done really, really well this time is I think her campaign team is much more, it's Utah-centric for sure, and they're very experienced on the ground here. So you have Dave Hansen and Kitty Dunn who are
Right.
spearheading that. They also spearheaded Orrin Hatch's re-election campaign.
Right.
They know what they're doing, and she has been working this for more than a year. And by working, I mean going out and meeting in these small counties
Right.
and small communities and
Right.
holding meetings with 4 to 6 to 10 people, up to big rallies and stuff. She does that as well. But she's very, very focused on Utah this time, and even though there is a real national presence, I think it's because on the national level people recognize she will be the incoming. I really believe the incoming congresswoman,
Right.
and they better get to know her, right?
Right.
Yeah, yeah.
Oh,
I think
So,
they saw
yes.
that 2 years ago.
Yeah.
Yeah.
Yeah, so she's really going to do some great things, I think, for the Republican Party on a national level. And it's not over, right? We know it's not over. We thought she was going to win last time. She didn't. But I think this time it's...
But
She'll win.
the surprises come when candidates don't treat their
Yes.
elections as
Well, I think
local.
that's what
It's
we
really
saw with
important.
Eric Cantor.
Right,
Exactly.
So the fact
right.
that she's
That's
doing
right.
that already,
And
she's been doing
and
it.
it's local, and it's phone calls
Yeah.
locally, and it's door knocking locally, and
Right.
parades locally. I mean, she's doing that,
Right.
and she's very, very good at that.
I think that's
okay,
great.
do you want to start with Supreme Court, or do you want to start with?
Let's
10th?
start with 10th Circuit.
All right.
Yeah, Utah
Fill us in.
specific. We're the
We're the test case now. For the
yes.
Who would have
Tell
All
thought?
right.
us.
So I'm not an attorney, so make sure you talk on my level. Thank you very much.
Give us a synopsis.
Well, here's the basic thing. So you remember in December of last year, Judge Shelby, federal
Right.
district court judge here in Utah, said our law was unconstitutional. Appealed to the 10th Circuit, and we get when you have those, you get 3 judges randomly assigned, and we got 3 judges. Unfortunately, 2 of them saw things in a way that the state didn't, and one agreed. Now that one is important because that sets up for the Supreme Court when they're going there. They have now 2 pretty strong judicial opinions up against each other. That helps to frame some things I think that are kind of interesting about this opinion. Is the majority opinion starts to veer in a very different way than previous decisions.
Yep.
They used to talk a lot about things like you're discriminating against a group of people for no reason. Here, the judges just admitted off the bat, no, people of Utah are not hateful and bigot.
Yeah, let me
we're
read
grateful
that
for
one.
that.
Although a
Sure.
majority's traditional view of a particular practice as immoral is not a sufficient reason for upholding a law prohibiting the practice. That's a quote from a case. And then the court says, for many individuals, religious precepts concerning intimate choices constitute profound and deep convictions accepted as ethical and moral principles to which they aspire. Courts do not sit in judgment of the hearts and minds of the citizenry.
Oh, wow.
Our conclusion that plaintiffs possess a fundamental right to marry and to have their marriages recognized in no way impugns the integrity or the good faith beliefs of those who supported Amendment 3. And we haven't seen a court say that yet.
No.
That's
So that's so why the
We've seen
change in tone then?
bigotry and
Well,
Yeah, you might have
I don't know if I have anything necessarily insightful, but it seemed to me, I mean, the different tack they took, right? Judge Shelby's decision was a rational basis
Yes.
decision, meaning he was looking at it from the perspective of, I don't see any possible rational, non-arbitrary reason that somebody could pass a law like Amendment 3, except, they don't like, they want to discriminate.
Okay.
And this court said, there's a footnote, I think, somewhere in the decision, said we don't have to deal with rational
11.
basis.
Footnote
because-
11.
Footnote 11.
Yes. It was really interesting to me because go ahead, yeah.
Yeah, because we're going to decide this on the basis of the fact that there's a fundamental right to marry that includes the right to marry a
Right.
person of the same gender.
Right. Which is Judge Shelby had talked about that, but then he had moved on to but equal protection, what do we do there? And I had worried about the jurisprudence of rational basis jurisprudence. I mean, if this didn't pass the muster of rational basis, then nothing ever will ever again. So that was honestly my concern. The court didn't even, like I knew, they always, if they can be narrow, if they can be limiting,
Right.
they'll always do it. If they don't have to reach an issue, they'll always do it. So here they just said marriage is a fundamental right, and the state didn't constrain it. What's the term? Not constrain.
Tailor?
Yeah, to narrowly tailor it to its purpose, and that was because they said it's not narrowly tailored because the state was always connecting marriage with procreation, and those two rights
Don't necessarily go together.
And that leads to another interesting thing about that decision, because in not reaching an issue, they said we're going to assume that the state's asserted interests are compelling. Right, which to me seemed to be a large concession, but one that those judges were willing to make because they took care of it on the back end, saying this procreation marriage link doesn't we don't buy it.
So again, from a non-attorney perspective, in December with the Judge Shelby decision, as I understood it, he was also making kind of a departure, and maybe he wasn't the first one, but it was a new argument to say this is more along the lines of Amendment 14, fundamental rights, anti-slavery, instead of this is a 10th Amendment right for the state to decide the laws within their state. And I think once Utah started to fall, I mean, it seems like there's a state every other day, it feels like, that's saying, that there's a legal decision.
The 10th Circuit really dismissed the federalism really quickly. What did you think of that?
Well, that's really an important, I mean, this is one of the reasons why having a dissenting opinion really helps us, because Judge Kelly, the dissenter, just jumped right in on that and said, look, when the Constitution is silent about something, that means it's for the states to decide. And what does that mean in principle? It's not just states because they're states and we like the, whatever. That's because that's where people actually make the decisions that affect their day-to-day life. So he's helping to frame this in a way that I think will be you get some sympathy from the Supreme Court, where they've been saying during this current term that it's up to voters to make controversial decisions on issues like this, and we have to live with what voters are going to say because they're closer to the issue. So I think that's a good. It's interesting because the 10th Circuit focus on the fundamental right to me is a little bit like leading with its chin, because the fundamental right arguments are a little complex. The Supreme Court at this point still at least says that in order for something to be a fundamental right, unless it's specifically written down in the Constitution, you have to show it's consistent with the history and tradition of the country. And so we're talking about a practice that didn't exist in the United States until 2004.
Which is what
So it's going to
Judge
be really
Kelly
hard
really talks about.
Yeah, it's going to be hard to pull off that idea that that's so consistent with our history.
But that's, as society moves away, this, how should we live? Let's agree on how we should live into a society of these are the rights that each person gets. More of an individual right to privacy, right? All these things that aren't in the Constitution, but now are protected, libertied interests. It's a different analysis. It's hard to go back.
No, that's
Right. Well, and it seems to me, from my perspective, that the individual right now, or rights of individuals, I should say, is trumping everything else. The rights of the family, rights of the state, rights of a nation. It's because it's all coming down now to if you want to do it, you can do it, and as long as we can create a legal reason for you to, that's what we should do. I mean, and maybe I'm misinterpreting, but that's kind of how I'm seeing it going.
No, that's exactly right. And I think, when you think about it from a child's perspective, which we ought to whenever we talk about family issues, they have to live in a world in which adults have been given all these rights, and they really have, they're not the ones voting. They're not the ones saying, hey, those judges are out of line. They don't have a say. We've got to think a lot more about, well, what do they say? Do they want a relationship with their mother and father, or is that just an extra for them? And these are questions that as a society, at least in Utah, we've voted with our feet in favor of children ought to be raised by their mother and father, or by a married mother and father when not. When the federal courts come in and say, well, that doesn't matter compared to this really important that these adults feel good about their relationships, that creates a situation I think is fundamentally unstable for children's interests.
So again, another question, and for you, you were trying to address this for me yesterday. Tell me the term. Is it en banc? Okay, so tell me about that. And what language is that? French?
Latin.
It's Latin.
It's
okay.
I didn't know
Isn't
what
it?
it was. I didn't know what it was.
Now I have to
So
Google
tell
it.
us what that is and how that would apply in this decision.
As you heard Bill mention, when a case goes up to one of the federal courts of appeals, it gets assigned to a 3-judge panel.
Yeah. And out of how many judges?
Oh, geez, I don't know how
It's
many are on the
different.
10th Circuit.
Right now we have
Really?
11 active.
Okay.
Okay.
So there's
There
11,
you go.
but each case is heard by a randomly assigned. Is it random?
It is random. There are
Okay.
11 active. There are other senior judges, at least 6 or 7. I don't know how many.
Okay.
A senior judge means that they have limited their schedule.
Okay.
So like when I clerked for Judge McKay, he was a senior.
Okay.
Instead of 4 clerks, he had 2 clerks.
Okay.
We still did the same amount of work, but we didn't have as much of it.
Okay.
And so when en banc is called up, senior judges, unless they were on that original panel,
Okay.
they're not included in the en banc.
Okay, so right now it would be 11
11.
instead of those 3. Okay,
2
so tell us
based
what
in
they
Utah.
would do. Oh, okay.
Matheson and McHugh, right?
Yeah.
Yeah.
Mhm.
Go ahead.
Yeah, and then they would hear the case again, and the hearing would be de novo, so it would be without any regard to
De novo would
deference.
be new?
So
New.
yeah,
Okay.
so this
So-
won't have any precedential value on what the new.
I'm not an
I'm
attorney.
not following- I'm not-
Translate for me.
Yeah, so there would be no deference to the prior decision.
Okay.
It'd be heard like
So
it's a
they,
brand new
so
case.
like timing wise, I mean, as I understand it, if you wanted to do that instead of having 3 people, then you would have 11 judges weigh in, and then whatever that decision, that would be what would go to the Supreme Court, because no matter how they ruled, it would be appealed, I'm sure.
Right.
Is that
Yeah.
my understanding?
Yeah.
And is it because you want more voices weighing in?
Yeah, it's
Okay.
because you've counted maybe and you think you have a better chance, or you don't know you have a better chance. And if, for instance, the Supreme Court decides not to take it, then this is what becomes law.
Yeah.
And if you had a chance to go en banc and you could have had it reversed or come out a different way, and you didn't take that when you had it.
Uh-huh.
But again, it's always
So
a Monday morning.
So
you
what?
know?
So what would happen, say, if you had it split the other way? If you had it reviewed now by the 11 judges and it went the other way, say 6-5,
Right.
What would happen then? Would they send
The
both of these
plaintiffs.
decisions to
No.
the? No,
It's only that one.
Yeah.
that one would go to the Supreme Court.
Yeah.
Yeah, and going to the Supreme Court is probably something worth mentioning because it's not a certain thing, right?
Right.
It's discretionary. The Supreme Court can decide to take this case
That's
or
right.
can decide not to.
Yeah, they're going to take it. Well, I don't know, right? I mean, they're going to
It's-
take a case.
Probably,
Yeah.
They're
yeah.
going to take, and
Yeah.
come on, they're going to take a case.
Oh, I think so. I think so, but
They're going to weigh in on this.
I think they would take Utah. I think they would take
it
this one.
wouldn't surprise me.
If they didn't take it, it would become highly, not precedential for other circuits, but really persuasive.
Yeah.
Other courts will start saying, this is what the 10th Circuit said, and the Supreme Court didn't decide to review it, so therefore kind of alluding to the
De
fact that they
facto almost.
agreed.
Okay.
Yeah,
Mhm.
yeah.
Okay.
So it would become, it's an important case regardless.
So tell me about the timing, because as I understand it, even this process is not a quick one, it's very lengthy. So say they were gonna, who requests this en banc review? Who does that?
Either party can request it,
And
but the
then-
plaintiffs wouldn't request it at this
Yeah.
point
So the
because
state
they
of
won.
Utah, so the state of Utah
Utah.
can request it,
Yeah.
like what would the timing be?
They have 4 weeks to request it, I
Okay.
think, 2 to 4 weeks.
And then,
And then it starts again to set a hearing date. And the 10th Circuit doesn't sit during the summer, and I don't think that they would call another special term to bring in all 11 judges to sit. I think they would do it in their September term.
okay.
So I think they would schedule, don't you think that they wouldn't do a special? It's hard to know.
It's just an oral argument, right? Not
It is just an oral,
rebriefing.
I don't think they rebrief. They can keep adding in, as you've noticed, some of the news media outlets in the state have been, oh, the plaintiffs put in another request, or,
Right.
every time another court talks about this issue, the parties can add
Okay.
addendum to their own briefings
Yeah,
up to the
okay.
10th Circuit and say,
Okay,
hey, look what they
okay,
did
yeah,
here.
Yeah, okay, like in Oklahoma or
Yeah.
something else, okay.
Indiana yesterday, or
Whatever.
and
Okay.
so, yes, all
Okay,
the other
yeah, yeah.
states that are doing it.
Okay.
And so they can add extra stuff, but they won't brief again. They'll set another hearing date. They'll do a whole another oral argument.
Mhm, mhm.
And then it'll begin another process again of 11 judges now deciding where they come out, who's going to write it, who's going to write the dissent,
Right.
and back and forth and things like that.
And then if it goes, so whether they do that or not, what's the process, what's the time frame of getting into the Supreme Court, and whether the Supreme Court will even hear it or not? Is that a year, is it 2 years, is it 3 years?
They have
Yeah.
90 days to appeal.
To the 10th
To
Circuit,
the
So that's
Supreme
mid-September
Court.
then.
okay,
Yeah,
to the Supreme Court.
to the Supreme Court, and then the Supreme Court decides when to take it up.
Couple of months maybe.
Yeah,
In
in the
November, we
fall.
would know.
Whether they're gonna take it
Set
or
a
not.
hearing maybe March.
Oh, that's faster than I
Decision
thought
next
it was,
year.
actually. I mean, even though it's kind of slow, it's faster than I thought it was.
Yeah,
For the
fast
law,
for
that's
them.
actually somewhat
Exactly.
better.
Well,
Right,
the
yeah.
Supreme Court is a little different because, as you see this week, they're done with their term and they're putting out all of their cases. The 10th Circuit doesn't necessarily, have a deadline to put their
Okay.
cases
Right.
out.
Okay,
So it's
All
a
right.
little more certain as to
great.
when we hear.
All right, are you ready to transition into Supreme Court decisions
Yes.
that came out? Okay, so tell us, Kurt, do you want to summarize?
Well,
there were two in the last day.
yeah, and the two that I think we're going to talk about are the Fourth Amendment case dealing with cell phones, where the Supreme Court said that generally you've got to have a search warrant before you can search somebody's electronic device after you've arrested them.
Right. It's more than cell phones. It's any electronic
Right.
device.
Yeah,
that
cell
they
phone
see
gets
there.
the headline, but
Yes.
Yeah.
that could be significant.
So
because it-
iPad, laptop, any of those.
In the car, they can't pick it up and start perusing it and get evidence.
So how is that? Is that different than what's occurring right now?
Yes.
Yeah. The focus of the opinion was because the argument that was coming from the police department. I think it was in California. I don't remember.
I don't either.
remember what it was. In fact, there might have been two separate cases consolidated. Was that there's an exception to the warrant requirement that's a search incident to an arrest. The idea being that if you arrest somebody, if you make a lawful arrest, you can search,
Like
what
you
is
could
on
search their vehicle.
yeah,
or-
what's on their
okay.
person in their immediate vicinity.
Okay.
And it's supposed to be for safety concerns.
Right.
Like for weapons or
Narcotics or something like
Right.
that. Okay.
Yeah, and the justices, this one came down unanimously, I believe,
Yes.
right?
Yeah.
Yeah, they had a lot of concern with that because they viewed it, and it was interesting to read the opinion and see the analogies, being much more like a search of somebody's home, given everything that's on your electronic
Right.
devices, your web browsing
you can
history.
recreate
All of it, yeah.
where you've been.
Yeah. So very personal. So they felt like to that level it had to rise to the level of obtaining a search warrant.
They have
Right.
to get a warrant.
So and then today's decision.
Well, hold on. So it's
Okay,
interesting
sorry.
for cases that are in the pipeline.
Okay.
Because there are just hundreds of these cases that are cases only because of evidence that law enforcement has received because they've looked at phones or they've done whatever.
So how is that? How will it affect it then?
It's up in the air.
Yeah, I don't remember.
Yeah, I mean, I would assume if you had a client who was convicted in one of these cases,
Absolutely.
you'd say,
You're
I
good,
wanna-
good,
I
yeah.
wouldn't have gotten that information in the first place. I
Right.
didn't get a warrant. And that,
Right.
I mean, obviously, it would have been wise to get a warrant initially,
Right.
anyways, to look at someone's computer, and that often happens, but it often doesn't too. And so,
Right.
And this goes along with the trend of the case a couple years ago that said that you have to have a warrant to do the place trackers on cars.
Yes.
That
Yeah,
was
the
also
open
law enforcement
placement.
they
Yeah,
were
they
really
were-
fighting for it strong and they lost that
Well,
case
they
as
had.
well.
Is the appeals court the Ninth Circuit out of California?
Yes.
So
Most highly overturned.
well, they were the ones that said you didn't need a warrant to place it on a vehicle that was in their own driveway,
Right.
unless it was behind a locked gate because the driveway was considered public access.
Right. That's
So-
crazy.
See, and the reason I know this is because I blogged about it, and it's just like, oh my gosh, because it's so dumb.
No, yeah. Well, and it's the same thing with with cell phones. This is I do not consider this public. I don't consider it open to my phone's in my pocket. I don't. That's what I was.
Reaching for the phone.
Yes. And
Right.
so it's nice to know that 9 of the justices, that
So-
we're not that far off. And
So Fourth Amendment has been in the news actually a fair amount over the last little while, I think in increasing frequency. Do you see this as a trend to kind of reverse some of maybe the direction we were going that was against personal freedom? Kind of the Fourth Amendment issues that have been coming up, or no?
Well, I think there's probably a piece of it is that we all feel a little bit worried about privacy issues. I mean, and not just the government. I mean, you just see everybody's looking at your history and all of that. I think there's a heightened concern that maybe we ought to make sure that some things really are kept kind of on our own and no one can see and participate in. So I suspect that's one of the reasons that we're getting a lot of attention. And of course, there are some conspiracy kinds of feelings too of like, what's the government
NSA.
doing? You watch enough superhero movies and you start
Right.
to worry.
Right.
What's happening to
Right.
me? So that's an issue too.
Well, and then you think of movies, that Tom Cruise movie where people were being prosecuted or, before because they were
Right, the
going
thought,
to.
yeah,
and
the thought
that's
police.
Where you go, yeah.
Only parents should.
Yeah. I hope that movie wasn't R. If it was, I didn't see it.
And the other thing that's always funny or interesting to watch is the Supreme Court dealing with technology.
Yeah.
And we're seeing that increasingly because they can't continue to dodge it and analogize. one of the things that was in this opinion was, California was advocating, well, let's just make analogies. So they can search anything on an electronic device that has a physical analogy, a non-electronic analogy. So an email is analogous to a letter or something like that. And the court said, we're not even going to go there. We can't. That's just too much for us anymore. That's just a can of worms that the federal judiciary can't and shouldn't have to handle.
Right.
Well, I
Get a
think
warrant.
Wasn't there, I don't think it was the U.S. Supreme Court, but I do think it was a federal judge who had, there was something to do with an electronic device, and because this judge was older and didn't actually deal with it, just dismissed it and said, it was something along the lines of like, well, who would ever put that kind of information on a cell phone, right? I mean, it was something along those lines. It's like, well, it's not like your telephone receiver from the wall where you pick it up and say hello.
Right.
It's like a computer, right? And that's, I mean, that's an issue as well.
It is.
In which case,
The
we're really glad for
generation.
clerks. Clerks are younger.
Thank heavens. No, but older cases especially, in the late 1990s and
Yes.
the early 2000s, there can be some really funny decisions to read because they rest on a total misunderstanding of the technology.
Yeah, that's interesting.
They get the tech absolutely wrong.
Well, and to their credit, the tech's going pretty fast in the past
It
10
is.
years.
It
And
is.
it's
Yeah.
getting pretty.
It doubles
It's hard
in
to keep up.
capability every 18 months, right? And that's been going since I think the 60s. So it's really quite remarkable.
Yeah.
Okay, the second Supreme Court decision, also 9-0.
Yeah, also
for
9-0, though this one masks a pretty sharp divide that's kind of
Yeah, a
lurking
lot of
behind the
news outlets
scenes.
didn't get that it was 9-0 at first because
Yeah.
there was a concurring opinion.
And so this one deals with recess appointments,
Yeah.
and has made Mike Lee very, very happy and vindicated, I think.
So give us
So
some background
article-
then, because you're the political writer and as well, but give us some background on what recess appointments are and why the Supreme Court took it up.
So Article 2 requires that that the president appoint officers of the state along with the consent of the Senate. When there is a recess, when the Senate is in recess, then the president can do it without the consent of the Senate. The wording in today's opinion. So there was it's the NLRB board,
Right.
the
National
president,
Labor Relations.
yes,
Yep.
board. The president made some appointments when the Senate was in what they were calling pro forma session, and under the President Obama's argument, they weren't in session because they weren't doing anything.
Well, that would be like every day.
Right,
So
right. They were empty.
They have been in session for 5 years.
Yeah, but the Senate's argument was, no, we're here, we're pro forma, we can be here if there's anything that needs to be done, and we get to say when we're in recess and not.
okay.
And so today's opinion talks about, sets the rule, kind of a bright line, and it's a lot of interesting talk about tradition and history, which
Yeah.
is why there was a concurring opinion, because they don't want tradition history, they want textual. But the bright line rule has now been a 3-day Senate recess is too short to make an appointment. And all of the other appointments within the past 200 years have been at least the Senate has been in session, have been in recess, or gone 10 days. Now the Constitution specifically says, defines an appointment or a recess as within the annual recesses. So within their, I'm forgetting the exact word, but they have the Senate has terms, and then they leave. And that's a recess according to the Constitution. But
At
tradition
the end
and
of
history,
the summer, Christmas time.
yeah.
As opposed to a short break in between the time
Yes.
where
Yes,
Yeah.
where they call it intra-session.
Yeah, that's right.
So inter-session is when the session is over,
Yeah.
and those are the breaks, the
Yeah.
traditional ones, as opposed to intra-session when they, okay, we're not going to do anything for the next 5 days, go home and come back, or 2
Right.
weeks, or whatever it
Right.
is.
Right.
And so tradition and history have been the presidents, all of them, Republican and Democrat, have been recess appointing during that time. The other textual argument that the concurring opinion had was whether the recess appointment had to be vacant at the time the recess started, or whether it has been vacant for 2 weeks or 2 months beforehand.
Yeah.
And according to the Constitution, it's supposed to be only vacant after the recess starts.
So
And so that's
So
why this
again-
concurring opinion with Scalia and
Yeah.
Alito and, the traditionally conservative ones
Yeah.
was very adamant about, I can't believe you're bringing history and tradition into this. It's supposed to be, the Constitution says this and this is what it should be. But they all ended up agreeing at the end that this 3-day appointment with this 3-day vacancy wasn't a vacancy. And the Senate
Right.
gets to decide when they're in recess, and
Right.
3 days is too small.
So answer this question: Is there really a need for recess appointments at all nowadays? We've got technology, we've got air travel, we certainly have. You can
That's a good
Skype in,
question.
secure. I mean, do you really need? Do we have a need for recess appointments? Period.
Well, yeah, when the Constitution was enacted in those early decades, you could see the situation where
Sure.
poor Postmaster General is sort of hands in his meal ticket, and you've got to find someone quick, and
Right.
so you do the recess appointment. Now it's become kind of I know my appointment is so strange that no one's going to approve them, so I'm going to just wait a little bit and then
Right,
slip them right
yeah.
in. And so I'm sure there's some response to that kind of feeling of, why are we even doing this? Why don't you just pick nominees that the
Yeah.
And the
And
NLRB
Senate
board,
will
like,
process.
what's the
What's
What's
the
the
rush?
what's the
number
rush?
one?
I gotta
Yeah.
get somebody in there right now.
Right. Secretary of State might be an issue.
Right.
But
Yeah.
But
Yeah, but really, I mean, is there really a situation where you could not reconvene the Senate in any kind
Not
of
anymore.
reasonable
Yeah, it's hard
time
to
frame? I
imagine.
don't. So that's one of the questions. So what was it that Mike Lee did? I mean, I know that right as those appointments were made, he was on the news talking about saying this is a problem. How was his involvement? How did it end up in the Supreme Court? Was he a driver of that?
do you remember?
I don't.
Yeah, he was the one that was talking about it over and over, and everybody was dismissing him, saying, "Oh, this is another, constitutional thing that he's just decrying, blah 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 blah." But it makes a difference, and it made a difference to him, and it was important, and he kept talking about it, and this is vindication, I think.
Yeah, I agree.
Senator Hatch was talking about it today, though. I thought that was curious. Like, well, this is Senator Lee's thing.
I have no comment.
They're both involved.
So, well, I think at the end, right, I mean, by the time it hit the Supreme Court, a lot of people had jumped on board and said, yeah, okay, we at least need to look at
And
this.
all
but-
9 justices,
Yeah.
At the end of the day, the deep divisions, notwithstanding, they all agreed it's an unconstitutional extension of executive power.
So,
Right.
so in the last couple of days, there's been a couple of smackdowns then of President Obama by the Supreme Court, which one I find quite interesting, actually, because I think he had been promoting the cell phone searches and certainly had been promoting the recess appointments. So does that mean his popularity is waning even among the left-wing liberal
don't think
judges?
I don't think he cares.
Yeah, maybe not.
Well, he's a lame duck, but
He was watching soccer on the plane today. But we were all watching soccer.
We were all watching
Yeah, that's
soccer.
okay. I'm not
okay,
saying
you want to
anything
start that?
against
I don't
soccer.
get soccer. It's like, really? You tie 0-0. You tie 0-0 and you won? Some guy bit some other guy? What is this, boxing?
We lost 0-1, and we're in.
Yeah, we lost 0-1 and we advanced. Okay, whatever. I don't get it. I like American football. It's good. Hit hard and win. So,
Yep.
anyway, so those are some big issues that have happened. Are there more cases in the pipeline? You're saying they're just wrapping up their session or their term? Are there
Hobby Lobby?
There's one more.
That's,
Yeah.
Hobby
that's the
Lobby.
big one
Yeah.
that
I
everyone's
think
waiting
it'll
for.
come on Monday.
Monday? Wow.
Yeah. So.
So talk briefly about that one because the Hobby Lobby one is Obamacare, correct?
You go ahead.
Well, yeah, that's right. So the question
Contraception?
is, right, exactly. So part of the Obamacare is a delegation to the Department of Health and Human Services to create some rules about what employees had to cover. They said, the most important civil right is for everybody to get their free contraceptives, and some religious people have balked at that. They say
Right.
we don't want to pay for these, particularly in the Hobby Lobby case. That they point out correctly that there are 20 different contraceptives that are covered by the rule, most of which, the vast majority of which they will cover for their
Right.
employees. But there's 4, I believe it's 4, that they have a concern have the effect of creating an abortion, and so they don't want to pay for that, which is fair. And so they're pushing back to say we're not religious people are not supposed to be conscripted by the federal government to do
Yeah.
what the federal government wants. If it's that important to you, you can pay for it yourself, or well, unfortunately make taxpayers pay for it, but it's a reality. But not to force religious people to do something that's against their own
Yeah.
beliefs. And that's Hobby Lobby is one of the
Sure.
parties. There's another one, a Mennonite family that runs a wood business as well. So, but this is going to be really important because all of the kinds of issues we're seeing, marriage and all of that, do have an element of how much do people, third parties, are they going to be constrained to offer services, to facilitate weddings, to
Sure,
provide
sure.
drugs, whatever. And so they're wondering how much are we going to be pinched if the government's position prevails here, which I hope it won't. That does create a really
Interesting.
serious challenge.
Well, and I expect that if they come down on the side of Hobby Lobby and say you don't in fact have to, that was going to have rippling ramifications with the implementation of Obamacare in many different
But all of
businesses
those
and
companies
avenues.
already have waivers, right? I mean, like, so there are, I mean,
only
it's
the
all
religious companies
waived
that haven't gotten the
anyway.
waivers. This
Yeah.
is a very distressing piece.
Exactly.
Of that,
All right.
Exactly. It's
Can we repeal Obamacare? That part? Okay. Okay, so really, that's been a really great discussion and fascinating. So let's do this again and,
Great.
and
Thank you for
catch up
coming
maybe on
today.
next
Thank you.
week's decisions. But thank you
Appreciate
for joining
it.
us today.
Thanks for having me.